facing the police every single day.
I'm good.
All right. I heard you're legal?
Yes, but not in Florida.
Oh,
Not in
come on.
Here's the thing about Florida. I've been
Do
practicing.
you know anybody?
Yes, it all depends on what area you want.
Free speech, civil rights. I was the guy they put in jail for free speech here.
Excuse me?
I was the guy they put in jail for free speech here.
Oh, really?
Yeah, Andrew Sheets. Free speech on a sidewalk.
Yeah.
That's pretty bad. Here's the good news, you guys. We sued him twice. Once in state on the appeal, we won that. And then in federal, that one's in settlement talks, and they're going to get rid of the free speech law where they ban free speech. So we are making a difference, but doing 30 days in jail sucks balls. I would like to get paid.
Yeah.
I would like to get paid.
Yeah.
So do you know any civil rights lawyers here?
Well, I know some lawyers here,
Right.
and you have your
I do have my card.
oh yeah.
Yeah. Yeah, do you got a card too?
I'll contact her.
Okay.
She's been around longer than I have. It's in
Wait, where'd you use to practice?
DC,
Oh, wow.
Maryland,
There you go.
Virginia,
Where you can actually get paid.
West Virginia.
Where you can actually get paid.
West Virginia. All of those.
Why don't they like to pay in Florida? I do not get it.
Yeah, Florida. And here's the thing about Florida.
Right.
They have no reciprocity. They don't allow attorneys who are not licensed in Florida.
That's correct.
To practice here. And if I wanted to practice,
Right.
let's say I've been out 35 years, they would want me to pay like $1,000 for each year
Wow.
for the application fee.
Wow.
So if I wanted to practice law that badly, why would I leave
Right.
the Washington D.C.
Right.
area to come here to
Right.
pay 35? If I were 25, yeah.
Right.
But not at my age.
Right. Why, how young are you?
I'm 66.
You're not dead yet.
I still have a lot of
I'm 57 and I'm fighting
Yeah.
for free speech, okay?
I've been around in the NAACP and I've sued police officers. I did a lot of
Thank you
I did
very
a lot
much.
of
Thank
civil
you.
rights.
Thank you, thank you, thank you.
My background was discrimination. I
Very
spent most
good.
of my time litigating discrimination cases in federal court. There's some of the
Wow.
toughest. There's some of the toughest cases.
Okay.
But I did more than the last 25 years of my practice. That's
Right.
all I did. Labor and employment.
Okay.
Sex, race.
I'm going to blow your mind then. This crucifixion of me is so out of control. Free speech on a sidewalk, they turned it into serving the peace, put me in jail for 30 days. Do you know the judge here, Judge Bell? He's the one that did it. It's just so out of control. I couldn't find a lawyer to do it. Don't have any money. They already took 25 grand of my money for this. Is insanity, okay? All right. I just sued the judge in federal court. First Amendment, Second Amendment, Fourth Amendment, 14th Amendment. Conspiracy, because we have documents to show,
That he was.
he blew away his cannons, and deprivation of rights under color of law. He knew and I knew what I did on the sidewalk was not illegal. You know that's not illegal. That's the ultimate public forum. And he crucified me anyway. Yeah.
Public property. But has the judge? You filed when?
I just filed brand new. Yeah,
Myers?
just saw. Yeah, you can look me up. Andrew Sheets versus Bell. So he's going to get served Monday.
That should be fun.
I know, right? But you know and I know you can do it if he breaks the law, violates his canons.
There's precedent for that if you conspire
Yes.
with, even if it's a non-governmental official,
Right.
to
Do what they did
take
to me.
the rights of
That's right.
another person.
That's correct.
Both the people can be liable for it. And if you have evidence of conspiracy,
We have the email.
based on what I know,
Right.
federal court's going to hold it. Now, it all depends on what judge you get sometimes, because some
True.
Some judges like to be narrow here, and they're very pro-government.
Right.
Which one of the
I
things
know.
in federal-
We all worship each other.
They're all pro-government, but there's some judges who will follow the law, and if you conspire, what they'll do, they'll find against the defendant.
Very interesting. So it's good I put it in there.
Yeah.
Because we have the email.
And conspiracy, if you have that meeting of the minds to deprive anyone of the civil
Correct.
rights, you can be held liable. Never mind you're a government official. Doesn't matter.
Are you giving me hope there is a tiny chance?
Yeah, you're not immune, because I actually had some of those cases in between police officers and a judge. Unless he or she is on the bench, then they're immune from when they're in the process of, for example, deliberating or giving instructions. But if they step outside the law, to conspire with somebody else,
that's correct.
They can be held liable the same as anybody else.
So I have a tiny chance.
A tiny chance. So the question would be the one of what evidence do you have and what does it show?
So can you legally, secretarially maybe help me once in a while?
Don't know. Here's what I'd be willing, depending on the issue.
Okay.
I would be willing to take a look, but because of my malpractice insurance, they have to be very.
Yes. No. Yeah, I agree. That's why I said it legally. Okay. I don't want to get burned because they like to burn people here.
Yes.
Yeah. So all right. Okay. Well, you got my email. I got yours. I will keep in touch. It's brand new, just filed, and. Yeah, we got to fight. If we don't fight, I want to go standing. What about you?
Yeah, absolutely.
I don't want to go on my knees.
Right, absolutely.
All right.
And I've been in lots of federal courts, and I fought for a long time. So I've not gone to the Supreme Court, but I've gone to courts of appeals, the state Supreme Court. I've done it all.
You would like my appeals lawyer for the illegal 30 days, Chris Cousin out of Fort Myers. You ever heard of him? He became a civil rights activist because of what they did to the blacks in the 60s. He is awesome.
I would, but send me, when you send me an email, send me a link to his bio. I'd like to read it.
Yeah, he's really good. If you read his appeal, woohoo, he's good. So anyways, good to meet you.
Okay, good to meet you.
I'll keep in touch.
Right.
Thank you.
Sheets v. Judge Bell. Civil action. Case number 2:22CV00035JLBKCD. $30 million lawsuit for violating free speech. Cause of action. Claim 1, First Amendment violation. The plaintiff has a clearly established constitutional right to free speech on a public sidewalk, which is the ultimate public forum. And the defendant clearly and maliciously destroyed all of that. Claim 2, Second Amendment infringement. The plaintiff has a clearly established constitutional right to bear arms and defend himself, and the defendant has clearly and illegally taken that away for a misdemeanor offense of free speech on a public sidewalk. Claim 3, the Fourth Amendment / Molly Cow's prosecution. The defendant instituted a criminal proceeding against the plaintiff. The defendant did not have probable cause to institute a criminal proceeding against the plaintiff. The defendant instituted criminal proceeding against the plaintiff because the plaintiff was causing complaints and not because the plaintiff was violating any laws. The defendant acted with malice and is still acting with malice as we speak. Claim 4, Fourth Amendment / unlawful arrest. The defendant did not have probable cause to proceed with prosecuting the plaintiff. Because free speech is allowed on a public sidewalk. Defendant knowingly violated the First Amendment, free speech. Claim 5, Fourth Amendment / unlawful detention. The defendant knowingly illegally jailed the plaintiff for 30 days for free speech on a sidewalk and free speech online, which are the ultimate public forums. Claim 6, Fourth Amendment / unlawful seizure. The defendant and his probation officer illegally seized the plaintiff's gun, even though the plaintiff was doing as the defendant's probation officer asked him to give away the guns, and then turned it into a crime. Claim 7, 14th Amendment violation. The defendant did deprive the plaintiff of life, liberty, and property. And the defendant did deny the plaintiff of equal protection of the laws. Claim 8, conspiracy. The defendant did work with 2 or more persons to conspire, for the purpose of depriving the plaintiff of the equal protection of the laws, or of equal privileges and immunities under the laws. The defendant did work with 2 or more persons to conspire to find the plaintiff guilty of free speech on a public sidewalk, which is the ultimate public forum. Claim 9, deprivation of rights under color of law. The defendant did act under color to willfully deprive the plaintiff of the right to free speech on a public sidewalk, and his Second Amendment right, and his right to defend the plaintiff's self. The defendant subjected the plaintiff to the crushing weight and burden of the criminal justice system every day for 17 months. The length of time between when the plaintiff was arrested and is still being prosecuted. We are in the appeal process as we speak. The defendant then tried to jail plaintiff and violate plaintiff's bond for not being at a calendar call, which plaintiff did not by law have to be there. And plaintiff lawyer was there. The plaintiff asked the defendant for motion to dismiss 3 times and was denied every single time. The defendant knowingly found plaintiff guilty of free speech on a public sidewalk. Defendant then told the plaintiff, you can't have free speech there but you can anywhere else. Defendant then told the plaintiff, I want you to think about those bad words when you are doing your community service. Then put him on probation for 1 year. Fined him $215. And gave him 100 HRS of community service and took his guns for a misdemeanor and any form of self-defense. Defendant then had plaintiff arrested again 3 days later for free speech again. Then plaintiff asked for a bond and the defendant used an illegal law denying a bond. Plaintiff then had a hearing to get the bond anyways. And then finally the defendant gave a bond, but said you could not use it until 30 days later. Plaintiff then asked the defendant in a habeas corpus, how can you do this? This is illegal. The defendant then asked the state attorney's office, what say you? They told the defendant, you cannot do this, there is no case law. And the defendant said, I will do what I want. The plaintiff finally got out 30 days later and is now in fear every single day of illegally being violated for probation again and losing his car to the bond. The defendant then made a plea offer that if the plaintiff stay off the internet and do not post any more stories of police court and government corruption, and he would not jail the plaintiff for VOP violation again. The plaintiff is independent reporter for 10 years. Plaintiff declined the offer. Plaintiff then filed a complaint with the Judicial Qualifying Committee of the defendant's illegal acts of violating the Constitution. Then the plaintiff filed a motion to recuse the defendant. Because plaintiff was in fear of retaliation from the defendant for filing the complaint. The defendant was not supposed to hear this and did the hearing anyways, and denied it. The plaintiff is now waiting to go to trial on the VOP violation. The defendant subjected the plaintiff to the daily dread and horror of facing the possibility of another arrest at any time, and jailing again without bond, and the possibility of plaintiff losing his car to the bond, and losing more time away from plaintiff's family, friends, church, and losing more business from the plaintiff's home cleaning company. Plaintiff also in fear every single day because the defendant through the probation officer stripped him of his guns and anything that can be used as self-defense, including pepper spray. Because the defendant and probation officer said, I'm a threat to the building where plaintiff protested abortion. Plaintiff informed them he has been assaulted 8 times. And none were charged. And has multiple stalkers for plaintiff's beliefs and causes. Defendant and probation officer have also stripped plaintiff's wife from any forms of self-defense including pepper spray. Defendant has caused plaintiff to spend $21,000 so far in court fees and fines, community service, lawyers and bonds. The plaintiff asked the defendant motion to dismiss a total of 4 times throughout this 17 months and was denied every single time. The defendant caused the plaintiff to be deprived of free speech and has taken away his firearms and any form of self-protection. Defendant tried to destroy his family and livelihood for 30 days. The defendants caused the plaintiff loss of dignity, loss of privacy, and loss of status. Caused the plaintiff to be subjected to mental and emotional anguish. And caused the plaintiff to be subjected to fear and anxiety. Regarding each claim against the defendant,